Mr. Patrick Tay.
Madam Deputy Speaker, I rise in support of this bill. There is no doubt that DNA evidence and identification have helped solve numerous crime cases in and around the world and has been a boon for law enforcement agencies in cracking many major, violent, serious and organized crime and have led to the successful arrest, prosecution and conviction of highly dangerous and wanted criminals. Notwithstanding, I wish to submit that there should be adequate safeguards in three important areas: DNA collection, DNA use, and DNA disclosure. I have 5 questions and clarifications for each of these 3 areas for MHA to respond to and clarify so that we are all properly and unequivocally apprised of the necessary safeguards as we embark on this DNA journey. First, collection. 1. There are numerous ways to collect DNA, and I hope MHA can enlighten us on the ways and methods in which the DNA will be collected, or maybe there might only be one method, so that we can better understand how invasive the process may potentially be. 2. My next clarification is whether young, youthful, intellectually disabled, aged, and other vulnerable persons will also be subjected to this DNA collection process. And as we know, some young offenders can still be in primary school, and I'm concerned that the process may be traumatizing to a young offender. 3. My understanding is that accused persons who receive a judgment of a DATA, i.e. discharge amounting to an acquittal, will not have their DNA collected, but those who are DNAQ, discharge not amounting to an acquittal, will have their DNA collected. Can MHA explain the rationale for this? 4. What safeguards will there be in place to prevent contamination of DNA in the entire collection and examination process? And 5, whether this collection and examination will be outsourced to private organizations outside of the Singapore Police Force. Second, use and storage. 1, I note that DNA collection will be for registrable offences, as some registrable offences may be petty in nature and some being more severe. What is MHA's rationale in deciding on this very broad, sweeping approach? 2, can MHA also share how the actual DNA sample, as well as the information data of the DNA sample, will be stored? 3, once stored, how is it protected and safeguarded so that it shall not be illegally accessed and leaked, whether by physical, cyber, or virtual means? 4, also for how long will the sample and the data on the sample be stored? And 5, and finally, whether the storage will be carried out by the Singapore Police Force or some external or private organization. Third, disclosure and disposal. 1, can MHA also share how and who this DNA data will be shared with and disclosed to during investigations, prosecution, and also in a court trial as part of the criminal discovery process? 2, will there be any chance where this DNA information be shared with law enforcement agencies outside of Singapore as part of worldwide police investigations, for example, as part of Interpol, or for laws with extraterritorial effects? 3, will the DNA information collected also be shared with agencies outside of SPF, such as CPIB, CMB, ICA, MOM, MAS, CRA, or even other agencies with quasi-enforcement and quasi-investigation powers, including with private organizations such as insurance companies when they investigate insurance fraud or corporate fraud, etc. 4, like other parts of the Act, there's provision for offences to be spent. Will it therefore follow that DNA samples be spent when offences are being spent? And 5, how will the DNA sample and data be managed in the eventuality of a disposal of the case? Notwithstanding the above queries and the need for safeguards, I support this bill. Thank you.